Right off the bat, this is how family court drama begins. The father's question isn't random. It's explosive. He's asking for DNA tests on his own children after years of doubt. Why? Because mom once said something out of anger that shattered trust. And in court, words like that carry weight.
Okay, and did you ever tell dad somebody else could be the father of the youngest two kids?
Probably out of anger, argumentative.
Boom. That's the reason why that he's asking for DNA. That's a legitimate reason to ask. Now just unmute yourself. Thank you. 19 on the docket calls 1515967, original petition modification and confirmation of arrears filed by the state. Would the parties please raise their right hands? You do solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
You both can put your hands down, sir. Please state your first and last name.
David Russell.
Ma'am, your first and last name.
Ebony McDonald.
Counsel for the state.
Gabrielle George with the Office of Attorney General.
Counsel for the state, you may proceed.
Thank you, Judge. If I may first start with Mr. Russell regarding service. Mr. Russell, did you receive a copy of the state's petition from me via email this morning?
Yes, ma'am. Yes, I did.
Okay, and is it correct that you want to proceed with the DNA request today?
Yes, ma'am.
What just happened? The judge made the record. Reflect, service, and consent to proceed. That might sound boring, but it's critical. In Texas family court, that one sentence locks everyone into today's hearing. There's no backing out now. DNA testing is officially on the record.
Judge, I would pass the witness and ask the record to reflect that Mr. Russell was served with a copy of the state's petition today and is asking to proceed with a request on DNA.
Let the record reflect the gentleman has accepted service and ready to proceed. You may proceed, counsel.
Thank you, Judge. Mr. Russell, you do understand that the state filed a motion to modify and add the youngest two children to the case today. Is that correct?
Yes, ma'am.
Okay, and the two children that we're asking to add to the case today, are those the two children you're requesting DNA on?
Yes, ma'am.
Now, you do acknowledge that in the hospital you did sign an acknowledgement of paternity for those two children. Is that correct?
Almost hear the father's frustration. He's not being hostile, he's desperate for clarity. In child support cases, DNA isn't just proof of paternity, it's proof of responsibility. He's saying, if I'm paying for these kids, I need to know they're mine. And the judge can't argue with that logic.
Yes, ma'am.
So why are you now asking for DNA?
Just due to the fact that it was numerous times, it was told that they might not be mine and stuff like that. It might be other guys and stuff. So, I still just want to make sure, if I'm gonna be paying for every month or whatever the case may be moving forward, I just want to make sure it's actually my kids and stuff like that.
Is mom the one that told you that the kids may not be yours, or was it someone else?
It was mom.
Okay, Judge, I'll pass the witness and briefly call Miss McDonald. Miss McDonald, did you hear father's testimony?
Yes, ma'am, I did.
Okay, and are you in agreement with his DNA request for the youngest two children?
There it is. The judge grants DNA testing. Quick, decisive, and fair. What's wild is how fast this escalates from casual argument to a court order. One heated comment at home just turned into a legal test that could redefine a family. Ever said something you didn't mean in anger? Imagine it becoming Exhibit A in court.
I don't agree. But I'm willing to do it, but I don't agree.
You're willing to do it, but you don't agree to it?
It's like I'm willing to do it with no problem, but I just feel the need of it is not sufficient enough for me.
Okay, and did you ever tell dad somebody else could be the father of the youngest two kids?
Probably out of anger, argumentative.
Boom. That's the reason why that he's asking for DNA. That's a legitimate reason to ask.
Yes, ma'am, for sure. To this day,
I'll pass the witness, judge, and ask for a ruling as to Mr. Russell's DNA request today on the youngest two children the state is asking to add today.
DNA is granted on the youngest two. We'll come back December the 10th, 2025 at 9 a.m. The AG's office will get you guys set up. Yeah, when you say things in anger, people don't know if you playing or for real. He got to take it as it's for real. We'll see.
I definitely understand, but can I say something, Your Honor?
There's nothing else to say. I mean, my ruling. Now, Miss George, do you need him to rejoin the breakout room?
Yes, please. Yes, okay. Judge. I'm gonna put dad in 1 and mom in 21.
Okay. So just wait right here. Mute yourself. Stop your video. She'll send you breakout rooms to join the sign.
Office of Attorney General.
Okay, this is a paternity action with temp orders in place from May 21st, 2025, and today is set for final. And counsel, is this a hearing?
Yes, Your Honor.
And how much time are you requesting?
15 minutes.
Okay, you may proceed.
Thank you, Your Honor. The state's going to call Ms. Maturino first. So, ma'am, we had the temporary order back in May of this year, correct?
Correct.
And you understand that we're here today revisiting the visitation issue and to address retroactive support, correct?
Correct.
Now, as far as the retroactive support goes, the state has calculated a total retroactive judgment of $30,522 as of May of 2025. Are you in agreement with the state's proposed retroactive judgment amount?
Yeah, that's fine.
And we're proposing that he pay that off at $200 per month starting October 1st. Are you in agreement with that?
Yeah, that's fine.
And that amount already includes a deduction for $800 payments basically that he had made to you over the last 4 years. Is that correct?
Correct.
I'm going to move on to visitation. The temp order did include sort of a step-up visitation period. Is that right?
Yes.
Did Mr. Reed ever make it to any sort of unsupervised visits at any point?
No.
Y'all were visiting, it was going to be every first, third, and fifth Tuesday and Wednesday of each week, of each month, correct?
Correct.
Let me ask about the Wednesday visits briefly. Did any of those happen?
No. Chloe, before any of these agreements were already set, she had basketball clinics that she needed to attend to, so we didn't do Wednesdays. It was more so Tuesdays.
Okay, so you weren't able to do any of the Wednesday visits?
No.
Did you try to reschedule any of those with Mr. Reed?
Yes, we tried to see if there's any other days that worked better, but he voiced that he had a busy schedule, so that didn't work out.
Okay. Now, you did do some of the Tuesday visits, correct?
Correct.
And you were supervising all of those visits?
Correct.
This next section is fascinating. The mother's describing uncomfortable visits. And pay attention to how she frames it, not physical aggression, but emotional discomfort. In family court, that matters. Judges distinguish between unsafe and uneasy. She's building a narrative of tension, not danger.
Generally, how would you say they went? Try to be brief because I have a time limit here.
They were decent. They were decent.
Would you describe them as uncomfortable at all?
Yes, we left uncomfortable both times that we did go visit.
Both times. So were there only 2 visits total?
Yes.
Since May?
Yes.
And prior to May, this was, the child had never met Mr. Reed previously, correct?
Doesn't know him from a can of paint.
Okay. Why were the visits uncomfortable?
I felt like he was more so wanting to kind of make the visits about me, or he'll say like little side comments, and it just made us feel uncomfortable. There were certain comments that I didn't even pick up on. It was some that she kind of mentioned to me, like more so on our ride home, and that kind of made her feel uncomfortable. But yeah.
Now going forward, you don't...
One second, and specifically, what were those comments?
Like for our first visit, he was a little touchy-feely with me. Mind you, I haven't seen him in like 14, 13 years, and that kind of caught her off guard as to why he was putting his hands on me or even, caressing me, trying to just put his hands on me, and that kind of caught her off guard and made her feel uncomfortable.
He wasn't violent or aggressive or threatening to you or the child, correct?
Correct.
Anything else that made the child feel uncomfortable or you?
Yeah, I just felt like he was kind of like doubting my parenting skills. He was kind of like giving like little smart remarks like, dang, I didn't think she was going to be this great, like as if I wasn't going to do a good job as a mother raising her. And, basically the good qualities that she did have, it was just like, oh, that's all.
It was a backhand compliment?
Yeah, more so, for sure. It was a lot of those. It was a lot of backhand compliments, insinuating that I was a liar and stuff like that.
And how old is the child again?
She's 13.
Okay, go ahead, counsel, for the state.
What is your request as far as visitation going forward?
As far as me,
His visitation with the child. What are your requests going to be?
I don't have a problem with the whole visitation whatsoever. I feel like if we were to be able to build that bridge of trust, I would love that. But it doesn't seem like that we were on the same page in regards to that. And as far as now, I mean, the child kind of has like a sour taste in her mouth because she kind of seen how he kind of came or approached the situation, and she's just kind of like, I guess she's at this point she's kind of like over it.
Okay. So he's only met her twice now total ever. You're requesting for now, anyway, that visits continue to be supervised?
Correct, if any whatsoever.
Would you be comfortable supervising that, or are you asking that they be supervised by a facility or a third party?
Preferably, I mean, if we could do it at a facility and then we could kind of go from there, yeah, but that's where we're at with that.
But would you be able to supervise if needed?
Yeah, I would.
Okay. And you said if you could build a bridge, so hypothetically, 6 months or a year down the road, would you be, if things were going well, would you be opposed to him having unsupervised visitation?
Yeah, but that's like I said, at this point, that's if she's even wanting it.
Okay. I'll pass the witness and call Mr. Reed.
Yes, sir.
So you understand we're just addressing the visitation and retroactive support today, correct?
Understood.
You're okay with the rest of the temporary order as it was ordered?
No, sir. If we could, I've actually offered it up in the initial meeting that we need probably a therapist involved, court-ordered therapy session because questions are arising up that are insulting my character. And like she said, she felt insulted. So I guess a mediation would actually be better, to rectify the foundational issues due to late parental discovery and traumatic issues.
Okay. Are you saying you're asking for a court-ordered therapist?
Yes, sir.
For what specifically? Or for whom?
For the relationship. We have to rectify any underlying issues before we can move forward. So.
Okay.
He's asking, do you want therapy for yourself, the child, the entire family? Can you set up the therapy for yourself?
I'm sorry, Your Honor. Yeah, I've set it up already.
Have you been attending your own therapy sessions?
I have, yeah. I've been attending over the years, and I'm actually
I'm talking about since this temp order, because you're specifically talking about therapy sessions regarding the child, you, the mother. Since this temp order, have you discussed that with the mother?
Yes, she actually said she didn't need it.
Okay.
She said, "See, we don't need it," and she actually stated that you saved me.
Okay.
Oh, the judge saved you. So, I mean,
go ahead, counsel.
I want to discuss the retro briefly. So the state is calculated, after giving you credit for $800 of payments that you made to the mom, the state has calculated retro support of $30,522. Are you in agreement with the state's proposal?
no, sir. Due to parental alienation and late parental discovery.
There's the hammer. The judge lays down final orders, supervised visitation, a $30,000 retroactive support judgment, and a strict path to earn unsupervised visits. This is classic Texas family court. Balanced, firm, but unforgiving if you slip. Notice how she even outlines the appeal process right away. No excuses. No confusion.
I am not.
The child's 13, is that correct?
Yeah, she is.
Oh, hold on, Miss Matrina. I'm talking to Mr. Reed. The child's 13, right?
Yes, sir.
Did you ever attend any of Miss Matrina's OBGYN visits when she was pregnant?
Yes, sir. I attended.
This case shows how thin the line can be between family drama and legal battle. One argument led to a DNA test. Emotional wounds shaped visitation. And a 13-year-old's future was decided in 20 minutes. In court, emotions don't win, evidence does.